Okay. All right, hello everyone. Welcome to the Michigan Lakes and Streams Spring Webinar Series. Thank you for joining us today. I'm Melissa DeSimone, the Executive Director of MLSA, and I have with me today Dave Maturin, who is President of MLSA, and also Attorney Cliff Bloom, who will be speaking with us today about riparian rights. So we're very excited about this session today, and again, thank the Glen Lake Association for their generous sponsorship of this series. We very much appreciate it. So I just want to go over a little bit of housekeeping. So like I said, this session is being recorded and will be available after our time today on the MLSA website. As a participant in this webinar, we cannot see you or hear you. So you can relax, you're not being recorded. And as we go through the session today, we will have time for questions and raising hand and things like that. So right now, if you come up with a question, you can put it in the Q&A box that is open to you to type in any questions. And either I will answer those by typing back to you, or I will read those to Cliff as he goes through his presentation. At the end, we will have time for live questions. So after Cliff's presentation, if you have questions that you would like to ask, you can raise your hand. There's a raise hand feature, and then I can unmute you so that you can ask your questions. So we will save those live questions till the end, but if you have any that come up during any of our talks today, please feel free to type those in the Q&A box. Okay, we're going to start today with a few words from Dave Maturin, our president, and I will turn it over to him. Thanks, Dave.
Thanks a lot, Melissa. Hopefully everybody's enjoying the webinar so far. It's unfortunate we couldn't be doing this stuff at our conference, but I think this is certainly an excellent way of getting the message out on a lot of riparian issues to our members. And we got a few more coming up too, some really good ones. So please check our website to see exactly what's coming up. We got some good topics and something we look forward to continuing. But more particularly, each year, Michigan Lakes and Streams Association selects an individual who's going on to an institution of higher learning who will be engaging in an area of study related to water or riparian issues. Our current challenges, such as high water, aquatic invasive species, certainly will not be solved easily. And new ones, whoever heard of PFAS until a couple of years ago, will appear on the horizon. So it's important that we have young people engaged in finding solutions to these problems. It's my pleasure today to award the 2020 Megan E. Cook Scholarship to Cecilia Denton. She's a senior at the Leelanau School in Glen Arbor and will be attending Northland College in Ashland, Wisconsin to study water science. MLSA will be sending a check for $1,500 to the college to help defray her expenses, so congratulations to Cecilia. She might have a word or two for us, perhaps.
Yeah, I do. I'm committed to attending Northland College in Ashland, Wisconsin, next door to the Apostle Islands National Lakeshore, majoring in water science at the Mary Griggs Burke Center of Freshwater Innovation. I'm excited to continue my work with water there, and thank you for helping make this opportunity possible through your scholarship.
Well, thank you very much, and we again appreciate your desire to get into something that's going to help all the riparians, not only in Michigan but obviously other states as well.
Thank you, Cecilia. Thanks for joining us today. All right. Well, thank you, Dave, for doing that. Thank you for joining us. Thanks to Cecilia. And I will turn it over to Cliff. He is going to talk with us today about water law and liability issues. And we're going to share. There we go. Okay. All right. So again, thank you very much for being here today, Cliff. And I will help you out with the Q&A. So just let me know if and when you're ready for some questions.
Thank you very much, Melissa. Thank you, David. Welcome everyone to the seminar on water law and liability issues. I'm Cliff Bloom from the Grand Rapids law firm of Bloom Sluggett, and I'm also legal counsel for the Michigan Lakes and Streams Association and the Michigan Riparian magazine. Couple things. First of all, if you don't recognize me, I've got my Corona beard on, and I'm not going to shave until we get back to the office. I was going to wear my U of M cap, but I thought I'd offend 2/3 of the audience, so I went with a fairly safe cap. Because if I don't wear a cap, like a lot of other people, I'd look like Tom Hanks in Castaway, so I really didn't want to do that. So I too missed the convention, but I very much appreciate MLSA and Melissa and all the support team of being able to do this. I guess this is the second best thing to the convention. As Melissa said, I welcome questions. I think that's one of the strong points that if we were at the convention of being able to question me, challenge me, and so on. It's a little unnerving in that I don't know if there's 3 people watching this or 300. So I'll assume that it could be either number or in between. So, and the final thing is, if for whatever reason, a family member of yours or friend couldn't see this, it is recorded and will be on the MLSA website for the future. So with that, I'd like to get started. The first slide is Bottomlands Trespass. And great, thanks, Melissa. We've really got 2 issues here, and we'll start with the ownership and usage rights of bottomlands, which is under the water. And we're going to have to break it up into 2 different areas, the Great Lakes and inland lakes. So let's talk about the Great Lakes first, because that's radically different than bottomlands ownership for inland lakes. On the Great Lakes, if you're a riparian property owner, you own what they call a movable freehold. So it's the edge of the water. And that can change overnight. Although the Michigan Great Lakes don't have tides per se, anyone who's spent any time on the Great Lakes knows that the water moves. It could be located in one position on a calm night tonight, and then tomorrow morning it could be 15 feet away. So if you're a riparian property owner, you actually own on a given day, on a given minute, to where the edge of the water is located if the wind was quiet and the waves weren't up and so on. So what does that mean? Well, on the inland lakes, the state of Michigan, the people of the state of Michigan own the land under the water. In most cases, the adjoining riparian property owner owns up to the edge of the water. And in the abstract, the riparian property owner would be able to preclude people from walking on dry land adjacent to the Great Lakes. And prior to 2010, there were many theories, legal and practical, as to what members of the public could do on the shoreline of the Great Lakes. Some people thought that you could basically walk on a riparian's property, excuse me, right up to the edge of the dune. It wasn't trespassing. Other people thought you could walk within 10 feet of the lake and it wasn't trespassing. Other people thought, well, as long as you're in the water, you're not trespassing, but if you are go on dry land, you will be. Others thought in the wet sand. So in 2010, finally, the Michigan Supreme Court case and the Glass v. Geckel decision definitively and likely forever decided the issue. And what the Supreme Court ruled for Michigan was that the public has what they call a servitude or an invisible easement on the dry lands of Lake Michigan on the Michigan side up to the ordinary high water mark. And people, members of the public, regardless of whether the riparian wants them to or not, can walk between the water and the ordinary high water mark, and the riparian property owner can't do anything. And certainly they can walk in the water also. So that's great, but unfortunately, ordinary high water mark is not real well defined. So if you're a riparian and you sue someone for trespass for walking outside of the ordinary high water mark, excuse me, and you go to court, you can't just point to any one thing. There is a statute that allows the Michigan Department of Natural Resources to set the ordinary high water mark on the Great Lakes for purposes of statutes and permits and so on at a certain level, but that's not necessarily definitive for the courts. So the courts look at this very vague definition of where the ordinary high water mark is, and likely if you had 3 hydrologists or engineers on a given point of Lake Michigan, they disagree on where that's located. So the law is now that basically if you're a member of the public, you can walk on the dry or wet sand lakeward of the ordinary high water mark on the Great Lakes. You can do other things. If your boat has to be beached, you have a right to do that. Can you walk dogs and other pets? Probably, if they're on a leash. Can you ride horses? Not sure. Can you ride ATVs and so on? Well, there are generally laws against that, but even if there weren't, we're not sure. Clearly, though, you can't stop. You can't lounge. You can't sunbathe. You can't picnic. You can't do any of those things because they're not travel. By the way, no corona problem. I've always had a scratchy throat. So now it's kind of a moot point because on most shorelines in Lake Michigan on the Great Lakes, the water is way above the ordinary high water mark. So until the waters of the Great Lakes recede to the ordinary high water mark or further lakeward, members of the public really can't probably walk on dry or wet sand anywhere in the Great Lakes. So only nature knows if this is the high peak of the Great Lakes. They thought it was last year, maybe. Now it's this year, maybe next year. And just so everyone knows, there's a really good Army Corps of Engineers website for Southeast Michigan that covers Lake Huron and Lake Michigan, which is probably the 2 lakes most of our viewers are familiar with. And as of 2 weeks ago, Lake Huron and Lake Michigan, which of course are one lake in actuality, were 15 inches higher than they were last year at this time. And we're kind of at the low point. So the odds are that the Great Lakes, Lake Michigan and Huron this summer could be anywhere from 6 inches higher to 14 or 15 inches higher than it was a year ago. So that's going to create all kinds of problems. This case has not been as big a problem as I thought it would be. It's been 10 years since it was decided, and I thought there would be all kinds of trespass issues, but in general, it seems to have worked relatively well. We're not seeing court cases and so on with riparians prosecuting trespassers. So in any event, it seems to be a fairly wise decision. What can you do if you're a riparian property owner on the Great Lakes since you don't own the bottomlands under the water? Well, there are countless piers and wharfs and seawalls throughout the Great Lakes by private riparians in the water that they don't own. So by state law and common law, which is court decisions, it's generally been decided if you're the adjoining riparian, you have somewhat of dominion and control over the water in front of you, but you can't do anything without a permit from both the state of Michigan and the federal government through the Army Corps of Engineers. So even though riparians don't own the bottomlands underneath the water, they do have a significant number of rights and so on. So Melissa, unless there's any questions on the Great Lakes, I'm going to move to inland lakes, if that's okay.
Yes, there's a couple of bottomland high watermark questions. So, I guess you can tell me if you want to answer them now or if you want to wait.
Go ahead.
So one of them from Stephanie says, do side lot setbacks that are specified by a zoning ordinance on a land parcel or access lot extend out over the water bottomlands?
Yeah, interesting question. The dominion and control on the Great Lakes and bottomlands ownership on inland lakes, which we'll get to in a minute, almost never extend at the same angle under the water as they do the side lot lines. There are pivot points where when the lot was created, a lot of times 100 years ago, that's where the riparian lines radiate out regardless of where the water is today, and it's almost never at the same angle. Zoning setbacks are an entirely different issue. Zoning setbacks are arbitrarily set by a local zoning ordinance, and sometimes they go out at a 90-degree angle into the lake. So you really got to meet both. You got to make sure your dock does not violate either the riparian boundary line or the side lot line. And we'll get to that more in a minute with inland lakes riparian boundary lines.
I remember there was one more question about the high water mark. Would the high water mark typically include the sandy areas adjacent to the water line?
It all depends on the particular stretch of Lake Michigan shore or Lake Huron, or obviously the other Great Lakes. It depends on the terrain. I mean, if you go on the Huron side and some of the Superior, it's all rocks, so there's no sand. On Lake Michigan, there's a lot of sand, but it's so high now that you know, the water might be over the ordinary high water mark. You might have a Lake Michigan beach where it's very steep and it has sand and so on. So really the only persons other than a court that can determine the ordinary high water mark with any degree of precision is probably an engineer or a surveyor. And what they would do is they would look at the DNR set site, plot that on the earth, and then try to figure out whether the common law definition would vary that a few feet one way or the other.
All right. Well, that was it for the relevant questions for this slide. There are a couple of other questions, but you may cover them later, so I'm just going to hold
Okay.
on to them for now.
Thank you. And Melissa, good news, we know we have at least 2 viewers now because they've asked questions.
What would you like to know, Cliff? How many viewers
do
you
we
have?
so far?
We have 80.
Oh, that's fantastic. Great. We'll see if those trail off or if we pick up some as we go.
We
along.
might.
So inland lakes are totally different than the Great Lakes as far as bottomlands ownership.
Mhm.
So for probably 95% plus of the inland lakes in Michigan, the adjoining riparian property owners own under the water to the center of the lake. Unless you have a perfectly round lake, though, those lines tend to be a little different than you might think. If there's a perfectly round lake, of course, it goes to the center of the lake like slices of a pie. If you have a perfectly oval lake, then there's what they call a thread in the middle. And so on the edges of the oval, people's underwater riparian boundary lines will radiate like a pie. If they're on the side, it'll radiate like a rectangle. If you've got an irregularly shaped lake, then it's anyone's guess. So almost never do they radiate to the center of the lake at the same angle as your side lot lines for obvious reasons. If I have a huge property that as you get to the lake, the side lot lines go in, I would have very little bottomlands out to the center because they come to a point. Conversely, if I have a lot shaped like this, see these great audiovisual representations, I could own the whole bottomlands of the lake almost. And if you did it that way, you would have bottomlands from different properties overlapping. So one of the layperson things I get a lot is, oh, I know where my bottomlands are. They go out at a 90-degree angle or the side lot line. And in about 100% of the cases, that's wrong. So the only way you can really determine it is 2 ways. One, to get a really good riparian boundary line surveyor, but that's only an opinion, and court action. So you got to sue your neighbor if your neighbor's dock is over your bottomlands and so on. Some surveyors can do riparian bottomlands, but not all surveyors can do riparian bottomlands. It's a very different art than regular surveying. Regular surveying tends to be numerical and fairly precise and objective. Not always. There are a few cases where lots overlap. Whereas riparian surveying, as many judges have said, is more of an art than a science. So if you have a property line dispute with your neighbor regarding an underwater riparian boundary line, it's really best to try to settle it. If you can't get a riparian expert and show it to your neighbor, if not, court action. And unfortunately, court action in these areas tend to be expensive, time consuming. You know, it just creates a war. You and your neighbor will probably never be able to patch it up and so on. So why are bottomlands ownership lines important? Well, lakefront property is valuable, and many of the lakefront lots were created 100 years ago or more, and they're small, so every inch is major. And only you can place your dock and your raft and your boats and your water nets and everything else on your own bottomlands. You can't put it on the bottomlands of your neighbor without permission. And only you can anchor a boat overnight on your bottomlands. So that's why it's really important. That's why people fight over it a lot, because a lot of these lakefronts are narrow. So what happens to people on the lake? Well, once someone legally gets on a lake, they can float or boat anywhere on the lake they want. So I as a riparian, can't put a fence to the middle of the lake, even if it coincides with my bottomlands. So once a person's on a lake, they can ice fish, they can, you know, walk on the ice, snowmobile on the ice, swim, float, boat, water ski, you know, et cetera, all over the surface of the lake. They can temporarily anchor for short periods of time for fishing or due to storms, help a water skier and so on, but they can't moor or anchor their boat overnight on the bottomlands of another person. So all of these issues are, you know, a big deal on these lakes. By the way, there are private lakes in Michigan that have no public access sites and legally don't have to have public access sites. I fight with people occasionally over this where they insist that every lake in Michigan has to have a public access site and does have a public access site, and that's not true. There are many, many private lakes without any public access sites in Michigan. Sometimes I think they confuse Michigan law with other states. I think Alaska has a law that basically says that every lake's got to have a public access site. So anyways, now there's some exceptions to this rule in inland lakes. You know, obviously if there's a road end perpendicular to the lake, that riparian doesn't control all of that. If there's an easement, sometimes there's a parallel dedicated walkway or park or whatever along the shore, which limits the control riparian owners might have. But we'll talk about that later. But if you're a riparian, you have the exclusive right in general to your bottomlands and shore. And you can also draw water, you know, for watering your lawn. You know, you can, like I said, do the boats and everything else. You can walk on the bottomlands, et cetera, et cetera, et cetera. What is bottomlands trespass? Well, it really isn't prevalent on the Great Lakes because once you're in the water, anyone can walk in the water. On the Great Lakes, the trespass issue is between the water and the ordinary high water mark. But in the lakes, obviously, if someone is on your dry land without your permission, they're trespassing, and you control that unless there's a walkway or road end or park or whatever. People have asked, what does the law say on people either congregating on a sandbar for hours and hours and hours and partying, or walking on your bottomlands? And unfortunately, the courts have not addressed either. Walking on your bottomlands is just really unclear. I think the courts, if they address the issue, would probably say a person cannot do that without your permission because that's not floating, but I don't know the answer. The sandbar or party boat thing is a huge problem on many lakes, not all lakes. The most extreme example occurred a few years ago. I don't think it's occurred much the last couple of years on Torch Lake, where there were various bars and businesses, particularly downstate, that promoted, you know, everyone go up to Torch Lake and put in and, you know, tie up and party. And I mean, literally a few years ago on the 4th of July weekend, there were tens of thousands of boats congregating. Or people will live or have property on an inland lake with a sandbar, which is a favorite area for the whole lake, where people come and wait on the sandbar and tie up, or there for hours and hours partying and so on. And admittedly, it's fun to be part of that, but it's not if you're the riparian and it's just offshore and the loud and so on. Again, the courts haven't addressed that. I think the courts would probably say no waiting on the sandbar, maybe even saying, look, partying is not a protected navigable activity, but you know, how do you control it? Even if courts said that, you'd have to sue people civilly. Almost certainly the sheriff's department, DNR, state police are not going to issue tickets because the law is unclear. I've had a couple of townships ask me about drafting an ordinance, but that would work. I mean, you could have a township, city, or village ordinance that deals with it, and then the police could issue tickets. But how do you do it? Do you say, okay, 3 or more boats can't tie out for 1 hour or more and do thus and such? It'd be a very difficult ordinance to to draft. I think some conscientious police agencies will use their discretionary power to go out and say, hey, break it up. You know, you've been here for 2 hours. And if people say, well, you don't have a legal right, officers can say, disturbing the peace and other things and so on. So some officers will help the property owners, but this is an exceedingly difficult issue to deal with if you're the riparian property owner with a sandbar not very far offshore, or you're on a peninsula or whatever. So it's just one of those areas where I have not seen a good solution, a good practical solution. So Melissa, any questions on bottomlands trespass?
Yes, we have a variety of questions. So I'm going to try to do these in a little bit of an order based on your discussion so far. Is it the center point of the lake or the center line of the lake when you're talking about bottomlands?
It depends on the shape of the lake. Almost always it's what they call a center line. Now, if your property happens to be on the edge of the line, your property is going to radiate like a rectangle or a trapezoid or whatever to that line. If you're at one of the points on the end, then it's almost like a point. It's the point at the end of the line, and your bottomlands will radiate like a slice of a pie, although it might not be like this. It might be odd shaped. And again, don't assume that you can figure out where it is without an expert. I mean, I would say out of 50 cases I've looked at with 50 property owners, predicting where they think it is, maybe 2 out of 50 are close. So I start with a proposition that every layperson, including me, is wrong on the angles. And I get a lot of, well, it should be this. And I say, well, should, would, you know, we live in the world where the deciders are going to be initially the surveyor, engineer, and ultimately the court. And the court's not just going to look at your common riparian boundary line. The judge is going to look at the domino effect, you know, half a dozen lots either way. And by the way, just because you've honored one for years doesn't mean that that's what the judge is going to decide, unless there's a prescriptive easement or adverse possession over 15 years or more, and we'll talk about that in a minute.
Okay, can a riparian owner install a fence into the lake on their bottomland?
No, absolutely not. That was decided 50, 60 years ago. And in fact, under most zoning ordinances, you can't even extend it up to the water's edge. Some zoning ordinances disallow fences between the cottage and the lake. Others allow you up to the ordinary high water mark. Others say, well, between the cottage and the ordinary high water mark, you can have a fence, but it can only be 3 feet high. Now, if you've got a private non-navigable pond where you own half of it, maybe. And by the way, let me touch on one other thing. I appreciate the person asking this question. There's also a distinction in Michigan, not only between the Great Lakes and inland lakes and public lakes versus private lakes, but artificial versus real lakes. So all these riparian issues I've talked about are applicable to natural lakes, inland lakes. We all thought it was applicable to artificial lakes until about 12 or 13 years ago. And the Michigan Court of Appeals in the last 12, 13 years in 2 different published cases has held that artificial lakes do not have riparian rights. Well, that's fine, but they don't say then what rights they have. That's like saying the earth is flat and once you fall off the edge, what's there? Well, we don't know. It's really disappointing. I hope that the Michigan Court of Appeals and Supreme Court eventually adopts the Illinois artificial lake rule, which says if an artificial lake has been used like, looks like, smells like, acts like a natural lake, it's deemed riparian. So in other words, if there's an artificial lake where they've water skied and had docks and swam and fished and, you know, used the waterfront after a certain number of years, it's deemed to be riparian. Because without that, we have no idea what the rights are. Can you have a dock? Can you have a boat? Can you swim? Can you ice fish? Now, unfortunately, the Court of Appeals, and I think the panels that decided these really didn't think it through all the way. And that is, they said, oh, it's really easy. All artificial lakes are implied that, you know, the developer developed, it has deed restrictions, the association will control. That's not true. Probably 75% of the lakes don't have deed restrictions, don't have a common owner, and so on. So I think it's going to create all kinds of problems. It hasn't yet. I mean, I haven't seen many lawsuits on it, but unfortunately, artificial lakes are treated differently, and we don't know bottomlands ownership. In the Michigan Riparian Magazine list, I think I've done at least 2 articles, maybe 3 on artificial lakes over the last 15 years. So your readers, if they get the riparian, great. If they don't, they should get it. And if they don't want to, some of the articles are available on the riparian website.
Yep, and I'm working on updating that right now. So we do have a question about impoundments, and I believe that would be related to this as well, correct? So the bottomland ownership for impoundments that's an artificial lake. And then the question, does the utility own that? Well,
you know, artificial lake encompasses many things. It could be a wetland that was dug out and became a lake, a la Lake Bella Vista, northeast Grand Rapids. It could be a mine or gravel quarry. It could be a small lake, 5 acres that was dammed up and is now a 500-acre lake. So when you say impoundment, I think you mean it was dammed up and so on. certainly Lake Bella Vista is a good example, and there are many other developer-created artificial lakes, particularly south of Jackson and southeast Michigan. They were done by plan. A developer did a very good job before they sold any lots. They've got a set of deed restrictions. They make the association like a local government. You have to belong to it. You have to pay. They have, and that's great. They control. In a lot of those cases, the association, i.e. all of them, lot owners together, jointly own it. But there are a few lakes in Michigan where one family kept the Bottomlands ownership and they managed the lake, even though other lot owners own it. There are a few impoundments that still exist in Michigan, not as many as there used to be, where DTE or Consumers Energy or one of the co-ops created a dam with a water flow generator and so on. Many of those have been removed, but the impoundment's still there. And in some of those cases, the utility company either still owns the bottomlands or has kept an easement. Also, some of those utilities over time want to give that up. A good example is outside of Grand Rapids on the Thornapple River. There was an impoundment that I think the Consumers Energy Company gave to one of the townships. So I would say, though, probably of all the artificial lakes in Michigan, of all the lakes in Michigan, probably 20% are artificial. And I mean bigger than a pond. I mean, it probably has to be at least 5 to 7 acres before we call it a lake. Out of all the artificial impoundment in lakes in Michigan, maybe 2%, 3%, 4% are owned by utilities, or utilities have easements. Not many. By the way, what I'm also thinking, a lot of these issues, I have in articles on my firm website at www.bloomslugget.com. I probably got 130 Riparian articles on there. I probably got 30 I did from LMLSA, and then I've got a bunch of other ones. So that's another good source.
Great. How about residents on man-made channels? Are they considered riparians?
Yeah, artificial channels, the answer is generally yes, if it was legally created. If it was illegally created, particularly in the last 10 or 20 years of violated zoning, and they didn't get a state permit, probably they aren't riparian and aren't supposed to be using the lake. But the courts have almost been schizophrenic in this area. There was a case on Gun Lake, which is south of Grand Rapids, probably in the late 60s, and I'm drawing a blank right now. I think it was Thompson v. ENZ. And basically, a developer dug channels into upland off of Gun Lake and made a housing development without any permits, state permits, in violation of local zoning and so on. That case bounced up and down between the trial courts, the Court of Appeals, the Supreme Court for years. And the Supreme Court finally said, you can't artificially create riparian rights, meaning on a channel. I don't think they had artificial lakes in mind. And therefore, it's illegal. Well, then the property owners who sued, the township that sued, said, great, issue an injunction making them fill in the channel or stop using it. The Supreme Court said, oh, they waited too long. Well, that was a cop-out. I mean, literally, when they first started digging it, the lawsuit was filed. So, but since then, the courts have ruled, well, you can't create channels, but you can't create riparian rights. And so the whole area is a mess. State officials today, Eagle, will rarely issue new permits for new channels or canals. Sometimes they'll issue permits for existing ones to be dug out, but that's an interesting point. Theoretically, a lake could sue the people along the channel saying you don't have riparian rights, don't use the lake. But I think if they wait 15 years or more, the courts probably are going to say, hey, even if you could have sued them earlier, if they've done it for 15 years or more, you sat on your rights, and we're not going to disturb that.
Okay.
Channels and canals present all kinds of issues, though. Who owns the bottomlands? How far out can you put a pier? All that good stuff. The bottomlands ownership, sometimes the adjoining riparians own to the center of the channel, sometimes they don't. Channels are often subject to various easements. If you're on a channel, you probably can't unreasonably block it. So you probably can't put a pier or a dock out further than is reasonably necessary. So canals and channels, particularly in Southeast Michigan, are a bit of a challenge.
So are there activities a riparian can prevent on their bottomlands?
Yes. Anyone who's wearing a Michigan State t-shirt or cap. See, I can't hear anyone laughing in the background. So. Can prevent, yeah. I mean, your neighbor can't put his or her dock or shore station or boat overnight on your bottomlands. No one could put a swim raft on your bottomlands. No one can anchor or moor a boat on your bottomlands all the way to the center of the lake overnight. So yeah, there's a lot you can do too. Now, you might have to sue them, which is not fun in circuit court because you normally don't get attorney fees and so on. You know, sometimes sheriffs, when I say law enforcement, it could be a sheriff deputy, a city police officer, a DNR officer, a state policeman. They hate getting into civil matters. And most of them readily admit they don't have the background in riparian issues. So most of them will not intervene. Now, I think clearly you have someone who is, you know, standing in your bottomlands for 5 hours. I think a police officer would say, hey, move. Maybe a dock or maybe a boat overnight or a week, if clearly he can see or she can see it's on your bottomlands, might say, hey, get the boat out of there. But yeah, you have a lot of rights if you're a riparian property owner. That's why riparian property is expensive. One of the reasons.
Okay. So here's one about coves. If you are in a bay or a cove, is it the center point of that cove or bay that would be the distinguishing point for your bottomland?
Really good question. It depends on how angular and drastic it is. Sometimes it'll have very little impact and it'll still go to the center of the lake. Sometimes they do multiple threads. So you might have, assume the bottom here is a cove. You might have a point not in the center of the lake, but outside the cove where they radiate to. So it can be really complicated for riparian surveyors and engineers. But yes, the answer is in some coves, you kind of have a two-tier system. You have a bunch of lines radiating to a point just outside the cove, and then that line goes up to the center of the lake.
Okay. Still some more questions. So,
Sure.
Okay. This one says, how far does the dock have to be from the property line?
I'm assuming they mean the setback from the side from the riparian property line. Well, in common law, the answer is it can't touch the underwater property line. Some townships, cities and villages have ordinances that say, look, it's got to be 10 feet away from the side lot line on land, and it either has to go to the center of the lake or radiate perpendicular. But that's a minority. In general, in most places in Michigan, there is not a local zoning provision or ordinance provision. And it's basically, you got to keep your shore station, your boat, and your pier or dock and everything else on your own bottomland, so maybe an inch off. There's no 10-foot rule. Some people think, oh, there's a general 10-foot rule for docks from the riparian boundary line, 5 foot from boats. There is no such rule.
Okay. What about hunting, fishing, or trapping activities? Can those be prevented?
Good question. I must admit, I know probably more about this than most people, but some of those common laws go back 150 years. And, oh, you saw the messy hair there for a second. And really, it has not been a huge problem in Michigan because generally hunting, trapping, and so on occurs on lakes that aren't as populated. But the bottom line is in Michigan, you cannot discharge a firearm when you're hunting. And I always forget, I think it's 450 feet. I think it might be 150 yards from a dwelling that's not your own. So that distance, it's a certain amount. But yeah, once a person gets on a boat on water, on a public lake, obviously you can't do it on a private lake unless you own there or you're a friend of someone who let you on. You can hunt and shoot waterfowl as long as you comply with all the game laws. You know, you need a permit. It's got to be in season. You can't unreasonably endanger anyone. You know, the good news is generally they use shot, which spreads out and doesn't go very far. So, you know, accidents to third parties during waterfowl hunting is just about zero. The pellets just don't go there. You know, there are accidents between the hunters and so on. Trapping's a little tougher. I think in general, I don't know for a fact, but you probably can only trap on your own property, bottomlands, because In a modern society, that causes huge problems if on streams and lakes you had these hidden traps that kids could get to and so on. Let me talk just briefly about rivers and streams. Although most people watching this probably are riparian owners or interested in riparian, we do have members of MLSA that are river or stream riparian owners, and the rules are very similar. You know, on rivers and streams, generally you own to the center. If they're navigable, you can't stop people from floating down and so on. A few of the bigger rivers are different. The bottomlands are actually owned by the municipality of the state of Michigan, like the Grand River, parts of the Kalamazoo River. If it's a navigable waterway, you can't stop people from fishing and walking on the bottomlands to fish or kayak or canoe. The test for navigability was whether 130 years ago the loggers floated timber logs down it or not. Some of the creeks are not navigable. Some of the creeks, even creeks that, you know, might be 15, 20 feet long, where maybe you could put a canoe down, you can't without permission. They're not navigable. They didn't have a log floated down them 130 years ago. So rivers, creeks, and streams the riparian issues are similar in what the riparians can do, but not exactly the same as for regular lakes.
Okay. People have lots of questions. What are the laws about folks using docks or floating rafts owned by others without permission?
Well, assuming that the dock and raft is on your bottomlands, normally other people cannot use them. Unless there's a storm or something, because no court or police officer in the world is going to begrudge them. But no, they're really not supposed to be on your dock or your raft as long as it's on your bottomlands.
There was another related question about that. Let's see here.
Melissa, while you're looking,
Yeah.
we're going to talk later about township ordinances regulating docks and rafts, but
Okay.
without an ordinance, there's two things that limit a riparian's ability to put a dockway out in a raft. One is you cannot unreasonably interfere either with navigability or the ability of adjoining or nearby riparians to use their property. So if your dock is unreasonably long, it might be a violation of the common law if you're impeding navigability. If your raft is too far out, too big, et cetera, impeding navigability, it could be wrongful. And there's also a statute that allows the DNR to require you to shorten or remove your dock or move your swim raft or make it smaller if it interferes with navigability. And if you ignore it and the DNR has to take action, you have to reimburse them for their costs.
Okay, so I found the question I was looking for. Is it legal for pond fountains, non-floating pond fountains, to be installed? If so, how far from shoreline, and do you need a permit?
Yeah, I assume they mean in a lake. I don't know. That's the first time I've ever gotten that question. It's possible Eagle or DNR might take the position that, look, although aeration is usually good, that might affect the lake or so on. They might assert that they have jurisdiction. I don't know that they do. The problem is you're probably going to make your neighbors angry. The noise is probably going to make them angry. If at night they can't get to sleep. So I suspect probably the state probably has jurisdiction. If it's a small one and it's not put too far out, will they do anything about it? If it's too far out, I think they'd say, look, it's distracting. It's in the way of navigability.
Okay, and then there was a question.
Oh, by the way, we do have
Oh.
issues with bubblers.
Mhm.
Now that's a big topic where we've done 2 or 3 articles for the Michigan Riparian magazine, and I get a lot of angry people when I address this issue. But there are, not a lot, but there are some municipalities that have bubbler ordinances. Now I'm not talking about the Great Lakes. Their bubblers are fairly prevalent on the Great Lakes with marinas and so on, but it doesn't present the safety issue it generally does in inland lakes. In the Great Lakes, there are permanent piers to be protected. Inland lakes, the overwhelming majority of municipalities and the state and so on do not allow permanent docks or piers. You have to take your dock or your pier out during the off season. Not always, there are some exceptions. And the feeling is that it's good for a lake for 5 months or so to be somewhat natural, to get in the piers, get in the docks, get in the shore stations. So it's not junked up over the winter. It looks good. It allows the bottomlands to regenerate. And most importantly, safety. Winter tends to be the lowest visibility time of the year because of wind and storms and snow kicked up. And a bubbler not only keeps open water next to the pier, dock, or shore station or boat, but it weakens the ice for a ways beyond that. So it really can be a lethal combination as far as children drowning, snowmobilers, ATV. You know, and another thing is, even if it doesn't weaken the ice, it's more likely that a snowmobile or ATV owner at night could be killed running into it, not seeing it. So I think the conventional wisdom is that bubblers really should not be in inland lakes in Michigan. And I think you're going to see an increasing number of municipalities prohibiting it. And I know that that will anger some people. They'll insist it's their right. And by gosh, I spent this money. But, you know, again, golly, I don't think it takes a rocket scientist to realize in most lakes it's not safe.
And then also related to this, what about herbicide? So putting herbicide in the water on your bottomland, recognizing that it will wander through the water.
Yeah, that's, you know, this is always controversial whenever you have a new aquatic weed treatment program on a lake. There are some people that are just anti-chemical and have concerns about it. They used to do harvesting. Harvesting is not done as much anymore because it wasn't effective and for a lot of reasons, although on a few lakes it is. You know, most of these chemicals have been used for 40, 50, 60, 70 years. They have to be approved by the EPA, Eagle, et cetera, et cetera, et cetera. It depends on the chemical used. The Department of Eagle will sometimes deny permits for certain properties. The problem with that is it's not just your property. You can object. You're effectively preventing people maybe for 2, 3, 4 riparian lots on either side from having their bottomlands treated. Other times the Department of Eagle will say, look, as long as it's done pursuant by municipality, pursuant to a statutory lake board or a special assessment district, we don't care. You can object all you want. Municipality is doing its thing and therefore you can't object. So yeah, it can be objected to. And, you know, I certainly respect people that have concerns, but you know, this is a common problem with True Green and, you know, I mean, they're just our lawns, or, you know, I mean, we're probably going to be sprayed for mosquito in Michigan this spring. Not many people remember now with the coronavirus, but last fall there were 2 or 3 counties in West Michigan, including mine, Kent County, where the triple E mosquito encephalitis mosquito was out, and it's 50% fatal from what they know if you get bit. So that's going to be probably sprayed around the state. So, you know, we're washing chemicals. I got it. That doesn't mean we have to add more. So in some cases, a riparian can object and stop it. Some cases they can't.
Okay, and then lakefront upgrades need permitting, but what do not? So creating a lake buffer versus placing boulders and things like that.
We will get to that in a
Okay.
little bit when we're talking about
great.
high water levels. But the bottom line is 100% of the time on Lake Michigan, Lake Huron, you need a permit, both a state permit and a federal permit. On inland lakes, it all depends on whether it's lakeward of the ordinary high water mark or above the ordinary high water mark. And by the way, ordinary high water marks don't normally move. I mean, they're based on physical characteristics or 100 years. That might change. I mean, if we're in these high water marks or high water levels for another, you know, 5 or 10 years, the law could change and you might have less property. It might move inland, which means you'll need more permits. You'll have less lake frontage. If you build a new house, you'll have to build it further away. So that might be a moving target over time.
Okay. A few questions about road ends. I don't know if you're going to get to that later.
We'll get to that later.
Okay.
So that kind of forces Melissa, the questionnaire, to stay on until that time.
Okay. Yes, it does.
Yeah,
Got to stay with us. I also see some questions about surveys too. If you have any
surveys.
We are?
Go
okay.
Ahead. I'll answer one, but then we got surveys later too.
Well, just if you had any recommendations of people who do surveys.
I do that. You know, I will say this, there are not a lot of real good riparian surveyors out there. Some surveyors and engineers don't do that much and they claim they can, but you know, it's kind of like non-water law lawyers practicing in water law. I would say in the state of Michigan, there are probably 10 really good riparian surveyors, but yeah, I can't make the recommendation in this.
Okay. All right, well, we can, let's see. Yeah, I think we can, well, there's might be one more. It says,
Okay.
my township does not have an ordinance to protect lakefront owners with regard to side lot setback. Neighbor has his dock directly on his lot line. Do you have any suggestions or advice to get an ordinance considered? He lives on a
Well, yeah,
private lake, about
yeah,
240 acres.
two things. You might want to get a riparian survey done of yourself, and if you're right, give it to your neighbor and say, look, I really don't want to sue you. Here it is. Yeah, I mean, they can do it in the zoning ordinance, or they can do it in a separate dock and boat ordinance. But I think a good thing basically says, docks have to be at least 10 foot away from the side lot lines as they intersect with the lake. Boats and shore stations at least 5 feet. Normally, your dock's got to project perpendicular, but you still have to stay within your bottomlands. So, yeah, I think they're good provisions. A lot of municipalities, once you explain to them why, do it. I mean, it's good government. And some will say, and I think this is almost funny, oh, we don't want to get into the lakefront. They have a right to do everything. That's their right. Oh, really? You've got a zoning ordinance that's 200 pages long. You tell me my house can't be closer than 10 feet to the side lot line. You tell me my house can't be more than 30 feet tall, yet you're not willing to regulate the waterfront, which is another real estate thing. So I think it's kind of inconsistent.
Yeah, and is a riparian survey a legal document?
It's an opinion, just like a regular survey. It's an opinion by an expert. But no, I mean, ultimately, if the parties can't agree, the neighbors, you got to go to court.
Okay.
And you'll use the riparian survey in court to try to convince the judge that your line is right.
Okay, and then some of these other things might come up later, so we'll move on. And if they don't,
Yeah,
everyone, I promise you we will get to your questions.
Let me say one other thing. People might say, well, geez, aren't the riparian lines already decided in your legal description of your deed? No, they're not. Actually, almost never, I would say less than 1% of the time, does the legal description go into the lake. Almost always they'll say, they'll have a legal description, and to the water's edge, and then 40 feet along the water's edge north and so on, or ends at the water's edge or whatever. And years ago, I had a friend call me. He had bought a lakefront property 5 years before, and he was all upset. He pulled his deed out of his safety deposit box, and he says, Cliff, I thought I was a waterfront property, and now I'm not. And I said, why? And he explained to me the deed, and he says, then it says ends at the water's edge. And I laughed, and I said, don't worry. The courts have said that if a legal description references the water lake in any way, you're riparian. So whether the legal description says along the water's edge, to the water's edge, ends at the water's edge, along the shore, to the shore, you're riparian.
All right.
So let's move on, if we can, to short-term rentals. This is in my top 5 areas of calls I get over the last 2 years. Probably number 1 is wake boats, and we'll talk about that in a little while. Probably then road ends, and probably bottomlands, ownership and encroachments, and certainly short-term rentals is number 4 or 5. And correct me, Melissa, if I'm wrong, but there will be a future webinar entirely on this topic on May 22nd.
That is correct. We're looking forward to it.
I'm going to talk about short-term rentals not only as a water law attorney, but as a municipal attorney. My firm represents about 60 cities, villages, and townships. So huge problem. There is no easy answer. At common law, without zoning and so on, someone could have a short-term rental and there's nothing you can do with it about it unless it's a nuisance and you sue and so on. Most zoning ordinances are silent regarding short-term rentals. These short-term rentals are normally located in a single-family zoning district, so you can't have 2 family renting it. That's clear. So end of story. That's easy. If you have 2 or 3 families renting at a time, it's illegal, period. How you police it is a different issue. But assuming the zoning ordinance is silent, many courts and municipal attorneys have said it's allowed as long as you're renting to one family. So if you rent to one family for 5 years or a year or 90 days or 2 weeks or a month or whatever, 2 days, as long as there's only one single family and they're using it like a single family residence, you probably can't do anything about it unless you amend the ordinance. Sometimes if you look at the definition of family in the zoning ordinance, it will determine it one way or the other. So I try to advise our municipalities, look, I don't care what you do, but you should address it, whether you ban them or allow them some places. In a lot of municipalities, they just don't want to deal with it. It's so controversial. It's tough. And, you know, what if you have 3 people that have rented it forever and they're responsible, and then all of a sudden you ban them because you know, how's that fair to the people that invested their life savings in a rental? Okay, more and more municipalities are dealing with it. Some of them are just banning them outside of commercial and resort districts. They're saying it's inconsistent with single family use. And I think the argument is what I call the rental car syndrome. You never take as good a care of a rental car as your own car. And that's true for a lot of people that are doing short-term rentals, you know, 2 days, a weekend, a week, whatever. They tend to want to cram everything into it because they're, you know, paying. So they invite over, even if overnight, their in-laws and their friends. And pretty soon you have the 4-person family. There's 30 people there and they're partying. And even though the rest of them leave except one family at 11, and they're just all these issues. So you never treat a rental car as well as your own. And I got it. Some people are very responsible, the owners and so on. Unless you have an owner of a rental who lives and stays next door, there's just not good policing of it. I don't care what they say. So some municipalities are just banning them in single-family residences or single-family residential zoning districts. Some will say, yeah, you can do it, but it's got to be for at least 30 days. Others are allowing it with restrictions and licenses. You know, some of the municipalities that I think have regulated this or amended it within the last 10 years is probably City of Saugatuck, Grand Haven, South Haven, St. Joe, Leelanau, Traverse City, Charlevoix, Petoskey, and so on. And some of them have a sliding scale. In certain districts, they promote them, they regulate them, they tax them. In other districts, they allow them under certain circumstances. Other districts, not at all. So this is a really difficult area. The concern I have, and I'm sure they'll address this in the May 22nd webinar, is a terrible word that I hate called preemption. Preemption is when the state of Michigan believes it can do things better than the local government. And it's hypocritical because those same state officials criticize the federal government when the federal government takes away state authority over things. So preemption is when the state of Michigan through legislation takes away local control. And they've already done it in 24 areas. The following areas your local township, city, or villages has little or no control: prisons, landfills, Right to Farm Act, mining, high power electric lines, withdrawal of water, et cetera, et cetera, et cetera. There are some legislators that want to take away all local control of the ability to regulate short-term rentals, or they're proposing a sham where they say you keep some local control, but they're a joke. It's a nothing burger. This would not be bad if the state would properly regulate those areas, but 9 times out of 10, the state does not regulate those areas properly. So it's the worst of all worlds. They take away local control and then the state doesn't do diddly you know what on it. So I hope they don't take away local authority. They will argue, oh, the local municipalities have all kinds of authority. They can regulate disturbing the peace and parking. Look, I've done municipal law for 36 years. That's false, absolutely false. There is no way a local municipality is going to be able to regulate trespassing, loud parties, drinking, swearing, staying up till 2 in the morning. Cities can do a better job because they have police forces and most townships don't, but even cities aren't going to be able to do it. So this argument that, oh, all the other ordinance, that's just, no, don't listen to that. The other thing I don't quite understand is some of the realtors groups want to preempt because they think it diminishes the value of the properties that can be rented. So when they sell them, they don't get as much. Well, I think that's short-sighted because I would argue that a short-term rental diminishes the value of the houses on either side, 2 or 3 down. So while it might diminish the value of the one house, isn't that better than diminishing the value of 6 or 7 or 8 or 10 houses adjoining it? So I would say listen to both sides at that webinar and ask them really good questions. So this is just a really tough area. Melissa, do we have any questions?
We did not have any questions about short-term rentals.
Okay. So the next one is high lake levels. As I indicated earlier, Lake Huron and Michigan are about 15 inches higher than they were last year at this time, which means, and we're at kind of the low level of the year, or almost at the low level. So huge problem. You know, on the Great Lakes are like an aircraft carrier, very difficult to turn around. And there's probably very little governments can do to lower the level. We're pretty much at the mercy of Lake Huron. Lake Huron is the big bathtub or pool that empties out into the other Great Lakes. The good news is Lake Huron is not quite as high as it was, so maybe that'll work its way through Michigan and Huron, you know, this year, whatever. There are a few things they can do. They can regulate the water that comes through the Sioux Locks and the St. Mary's River. I think there's some things, although I'm not an expert, on Lake St. Clair. I know the Chicago River, they can do certain things. I think in Ontario, there's certain rivers and so on they can regulate, but physically, there's probably little that government can do to speed the lowering of the lake levels. Someday they might be able to do it via pipelines to the west, but that'll be its own controversial decision, which by the way, wouldn't be a bad idea if you could turn it on and off depending on the level in Lake Michigan. But the problem is even when levels are low, the west would still want the water. Inland lakes are also at a high level. Most inland lakes are not directly tied into the Great Lakes, so it's not necessarily the Great Lakes that are keeping them high, but a series of other factors that have happened. So what can be done to mitigate the problems to riparian properties? Well, on the Great Lakes, you know, the main thing is to put in riprap, which is rocks. I found out years ago that's a fancy way of saying rocks, big and small. Sandbags, groins, seawalls, flanges, etc. And the problem is different depending on where you are. If you're Grand Haven, Holland, Montague, North, the problem is houses falling off the cliff, excuse me, the dune or the hill. So that type of bracing at the bottom is one thing. If you're down by St. Joe in those areas, it's flatter. So you don't have to worry about your house or cottage falling off a cliff or a hill or dune, but just flooding. So the solutions are a little different. Anything occurring lakeward, you're going to need a permit, probably even now, even if it's not lakeward, but it's in the water. So you need both a state of Michigan permit from Eagle and an Army Corps permit, although I think those are unified. I think if you apply to one, they'll handle both of them. I do know that there are some emergency rules in effect that allows a property owner to get those permits a lot quicker, probably cheaper, but you still need a permit. So again, if you hire a good contractor, he, she, or it is probably going to handle the permitting, but make sure they do it right, because ultimately you as the property owner are responsible. And it's heartbreaking on Lake Michigan in particular. I represent a township, White River Township, north of Montague, where they estimate 20 to 30 cottages and houses are in the danger of falling in the next year. So it's really tough. Some of these cottages have room where they can be moved back, although we're probably going to have to grant variances so they can violate the rear yard setback. Some folks have nowhere to go. There's really no federal or state funds available for private, you know, riprap and groins or removing the houses. So it really is heartbreaking. On inland lakes, happily, there are more solutions potentially, although in a particular case, they might not always be good. You know, one way is to set a formal lake level. Now, usually I'm working on the opposite. Lakes are low and people want to dam them up or do a well to pump, but the same process works if you want to get water out of a lake. So there's about a 50-year-old statute called the Michigan Inland Lake Level Act, which allows the county commission either by petition or on its own to go to circuit court, and the circuit court sets a lake level, usually now a range, and says, you know, you either have to install a dam, improve a dam, you know, dredge an outlet, put in an outlet, pump, whatever, and it orders the drain commissioner to do that and funds it by a special assessment district. So that's really the only way. You can't take self-help. It's illegal. The liability potential is huge. The Lake Level Act is the best way to do it, but that can take 8 months to a year to do. And you got to have some way getting the water out. The judge isn't going to say, oh yeah, put a big pump in there with a big hose, because that's going to affect everyone downstream. So that's really the only formal way you can do it. as far as the shoreline, same thing as in the Great Lakes, riprap, seawalls, etc. But in that, you don't need an Army Corps permit. You need an Eagle state permit, unless you're on one of the inland lakes that ties into Lake Michigan, Huron. Then you need both. So again, I think Eagle, in particular, is trying to issue those as quickly as possible, and so on. Will the ordinary high water mark move? Not this year, not next year. If this keeps up for many years, maybe. And then you're gonna have to build your new cottage or whatever further away from the lake. So those are some general ideas. On inland lakes, it's also a problem. I mean, we've had properties where the septics are underwater. They can't use their cottage. We've got gravel roads and paved roads and cities that have never been flooded that are close to being flooded, where they might not be able to be used. So everyone's fighting it all around the state. There are marinas this summer that won't be used. There'll be state parks where the boat ramp can't be used, and no one's got any money. The road commission is fighting it, the DNR is fighting it, townships, cities, villages, and unfortunately no one has any money. So hopefully this will be the last high water year and it'll go down, but you can't bet on it.
Did you have any comments about the state septic law and its impact on Michigan lakes? You touched on septics a little bit, but we had a question about that.
Well, there is a state health commission or health code that deals with septics and so on. It's administered generally by counties or groups of counties together. So really, it's a health department issue. But yeah, I mean, if your septic field is covered by water, you can't use your house or cottage. I mean, it's just that simple, unfortunately.
And then there's a question too about the controlling law for a natural lake or pond that has a dam that raises the water level 3 or 4 feet. It's just asking what your best guess about the controlling law. Well,
most of the time where there is a dam, you've got a court order, and if there's not a court order, you should get a court order. So there are dam statutes that deal with safeties of dams and construction, and there are state regs and how often they have to be inspected. But the key statute is the Lake Level Act and setting it through a court.
Okay, and I think that answers this other question too about who controls the lake levels. So that depends upon. Well,
if you've got a lake level circuit court action, it's usually the Drain Commission and the court. If you don't, then no one does, and that's the worst of all worlds. And if you don't have a lake level set, you try to do it yourself, you're incurring a huge amount of liability on you and your lake association.
And then also, you may talk about wake boats later, and this is slightly related to that. You will? Okay,
well,
then we will.
Yeah, wake boats and other boats are creating huge problems with these high waters on the shore, and yeah, that's a problem, and we'll talk about that later. So,
okay, yeah.
Melissa, I'd like to move on if that's okay.
Absolutely.
We're going to talk about lake access devices. And I'm going to group these, and I could do a whole hour and a half on just this, so I'll whet your appetite. So there are a lot of ways where the public or non-riparian property owners can access and use a lake. There are what I call the perpendicular ways, which are road ends, easements, alleys, and so on. So those tend to be perpendicular, and those tend to be access only. There are parallel things along the shore, lakes, parks, alleys, and so on. And those generally, other than the parks, parallel walkways and roads do not allow lake access. They only allow travel. So those are generally easements, and generally the riparian property owners own under and through those parallel alleys, parallel walkways, parallel roads, and riparians can put in docks, boats, and so on, so long as it doesn't interfere with the travel both ways. Parks are different. In most cases, the riparians own under the parks, but the public or people within the plat, depending on the dedication, normally can lounge, sunbathe, swim on the parks, regardless of what the riparians want, but they can't put in their own docks and boats, okay? Perpendicular ways, alleys and walkways and roads, whether they're public or private, the universal decision by the courts has been access only for public or backlot owners, depending on what created it and whether it's dedicated to the public or private. Travel, carry canoes on, carry small boats on and off, ice fish, snowmobile in the winter, but public, backlot owners, no docks, no boats, no overnight boat moorage, etc. And that's pretty clear, and that's clear about 95% of the time. For public road ends, MLSA helped to get in a statute about 7 or 8 years ago that says on a public road end, no private docks, no shore stations, no overnight boats, and if you do, it's illegal and you can be ticketed. So in a nutshell, that's kind of that area. And again, we could go into this, in depth, but local townships, cities, and villages can regulate those even more. They can't allow uses that aren't allowed by common law, but they can clamp down on them. To get these devices changed is almost impossible. You got to do a really expensive plat vacating process in circuit court, and it's almost impossible to do. So, Melissa, I'd be glad to take some individual questions if people have interest in those.
Okay, let's take a look here. All right, let me make sure I'm not missing anybody. And I do apologize if I'm skipping around a little bit. I appreciate everybody's patience. All right, so is it against the law for backlot owners to put a dock on a road end and moor a boat all summer?
Almost always it's civilly impermissible, and if you sue them, you're almost certainly going to win. It's not illegal, it's a civil matter, so police officers can't issue tickets. If a township has a road end ordinance, the township can issue tickets. So civilly, I would say 95% of the time or more, it is improper. They're doing what they're not supposed to do. The backlot owners are almost certainly going to lose in court, and they're taking on a huge liability. Since they're not supposed to have a dock or boat there, if someone is killed on that dock or that boat or whatever, the liability is going to be huge. And they could be prosecuted for negligent homicide or manslaughter because they're not supposed to be there to begin with.
Okay, and then who does own that? Oh, sorry.
Almost always the adjoining riparian owners own to the center, and it's an easement. And this sounds cruel and cold-hearted, but that's why lakefront property owners pay more. The other problem with this assertion that backlot owners can do that is there are too many backlot owners. You can't accommodate them all anyways. If you have a 50-foot wide road end or easement and you have 100 backlots, how are you going to allocate that? You can't. And first in time, or I'm bigger and I can beat you up or whatever, the law doesn't recognize any of that. So in almost all cases, if you're a member of the public or a backlot owner, you can't have a dock, overnight boat. You can't even lounge and sunbathe normally, unless it's a park.
Let's see. This person asks, does that mean no mooring by backlot owners on parks that are owned by a private lake association?
It depends on the timing. The courts have said overnight, definitely not. You can temporarily do that while you're letting people off or putting people on a boat. I think probably if the courts had to address it, which they haven't yet, it'd be what I call a presence rule. I think the backlot owner has to be present with their boat. On a park, I think they can be lounging and sunbathing next to it. Look, you pull up, you let people off, you run to the bathroom, come back. No one's going to hassle you. Can you leave it? Can you pull it up at 8 o'clock in the morning, leave it there till 10 at night, and not be there with it at any time? No, I think that's probably not lawful.
Okay, so
and by the way, you couldn't do that at the public parks. Granted, in those parks you can't do that, but you can pull up temporarily in most parks, public parks.
Does adverse possession or prescriptive rights apply to a non-permanent dock that goes out and comes in the seasons?
Yeah, it can, but I'd like to wait until we get to that.
Okay, great. Let's wait on that one.
I do have some diagrams on here, particularly parks and so on for your information. I think that's self-explanatory. In most of those cases, the first-tier lot owners are riparians subject to the easement for park uses.
What defines a public road end? That's a relevant one there.
Well, they're almost always created in a plat, and the plat will say the roads and alleys are hereby dedicated to the public. So almost always, or there are what they call highway by users where the road commission has jurisdiction. Those are public roads. Private roads are dedicated in a plat to just the people in the plat, or they're private easements created for certain lots.
Okay. Can an association rent mooring sites? Can they rent?
Not at a road end, not at a public, a platted dedicated park, alley, no. If the association owns its own riparian lot, depending on the local zoning and how the association was set up, maybe.
Okay, and then do deeded accesses end if they are not used?
I hate the word deeded access. It's a weasel word that some, not all realtors use. There's no such thing. The courts have never recognized that. People use it all the way from public road ends to private road ends to easements that only serve one lot and so on. So deeded access is a terrible word that should never be used. No, almost none of them go away. If they're dedication, a dedicated plat, road end or whatever, you have to go to court to get them extinguished. That almost never happens. If it's a private easement, you'd have to get all the beneficiaries to sign off, and that's almost never going to happen unless you pay them a lot of money.
All right, and I think this is the last one before we can move on. What happens if there's some space to the lake from a road end that is undefined?
It's a very good question. And it's not only between road ends, but between lots in the lake. And by the way, you have to go back to the original plat. It doesn't matter now. I mean, let's say this is dry and the lake was receded by 100 feet out. Are you still riparian? Yes, you are. You own to the center of the lake. So when it's exposed, you own that. The courts have generally held that if there's a little strip of land between a lakefront lot or a road end or whatever, they normally ignore it and just say it goes all the way to the lake. Unless it's fairly broad and the original platter reserved the land strip. If someone reserved the land strip, then those lots and road ends were not riparian. But by the way, to complicate it, they might be now, because if the first tier lot owners have used it like their own for 15 years or more, they can claim it. So generally, small land gaps are just ignored by the courts.
Okay, and then a related question. So there was a situation, but the gist of the question is, where can you find archives or maps or information about a plat? Because there's a disagreement about whether something can be used or not. So basically, just how does a layperson find an answer to a property dispute?
Let me tell you, 9 times out of 10, the answers on the original plat, which could be 50 years old, 60, 100, 150 years old. County maps, lay people maps, all that are nice, but they're almost always legally inaccurate. So you got to go back to the source, the original plat. Every county register of deeds in the state, I always forget whether you had 82 counties or 83 counties, has them. And you can go and get a good photograph. A lot of us are disgusted with LARA, State Department of Labor and Regulatory Affairs. Not all of them, but just whoever did this. For 25 years, there was a great search engine where any layperson in the state, including me, could click about 3 times and get a plat. Virtually any plat in the state, you know, what county, what was the name, and so on. Worked wonderfully. We loved it. Oh, about a year ago, Laura updated it, made it more user-friendly. You go through about 97 steps. I can't do it. I have to have my secretary do it. So the more people that complain to Laura about a system that worked well for a system now that everyone's tearing their hair out, please let them know your feelings on that. So why they did that, we don't know. So yeah, there is a way for you to get plats, and I'm joking somewhat, but I think you still have to go through 7 or 8 different steps, and it's a lot of times not worth it.
Okay, well, I think we can move on for now.
So we're in property owners associations.
Okay, so here's those.
Yeah, go a couple through, Melissa. I think it's number 9.
Okay.
Yep. So this is a real technical legal terminology, strong associations versus weak associations. And you will not find this in the law. So probably 95% of the lake associations around Michigan and river associations are what I call weak. They can't force you to belong. They're voluntarily only. They're social, educational. They might do weed treatment. You don't have to join them. You can quit them. They have voluntary dues and so on. Because in the end, they can't force you to do anything. Then there are what I call strong associations, which are probably 5% or less. And most of these are on artificial lakes. There were one property owner and developer owned the whole body of water, and they recorded a set of deed restrictions that set up the association, require you to be a member of it. The association has dues, you have to pay it, and a bunch of other areas. So those are strong associations. there are a few old summer resort association statutes in Michigan, and we probably have 100 or fewer of these that are set up, and they're strong association by statute, but there's very few of them. Most associations don't want to become one of them because they're archaic and it's not even clear whether they're legal today. So again, most associations are weak because they're voluntary. A few associations are strong, most of them because of deed restrictions. Melissa, any questions?
Nope, no new questions right now.
Wake boats. Okay, let's see how many people I make mad at me. I've done 3 or 4 articles for the Michigan Riparian magazine over the last 6 or 7 years, and I think they're worthwhile arguments or articles and arguments. These, I'm calling them wake boats. They're different than speed boats. They're not the same as speed boats because they have an artificial apparatus or bladder that allows them to take in water and rise up, have more mass, and create actual waves and back. So not only can water skiers be in back of them, but wakeboarders with no ropes. They're a lot of fun. They're expensive. A new one will cost you 75 grand or more, and a lot of them are over $100,000. Sometimes they're called wake boats, sometimes wave, W-A-V-E boats, sometimes bladder boats, and there's some other names for them. So on the one hand, they're a lot of fun. There's no question about it. They're one of the fastest growing segments in the boating industry, and candidly, they're probably keeping the recreational boating industry afloat, pardon the pun, because while some of the other boat sales were down before the coronavirus and will probably be down even more after, these have really boomed. The bad news is they create wakes that can be huge, and those wakes and waves are not only above water but underwater. So if you create a 3 or 4 foot wave above the water, there's a wave underwater, maybe not quite as much, maybe 2 feet, 3 feet or whatever. And if you operate these too close to shore, what happens is the artificial waves destroy seawalls and groins and lawns and moorings and piers and docks and, float boats that aren't supposed to be floated and swamp other boats and so on. They can turn on and off the wave apparatus. So these can be used as conventional water skiing boats without the wave making apparatus. And it's a factor of distance. So if a wave boat, and by the way, these wave boats can also swamp sailboats and so on, well beyond the 100-foot level. High-speed boating, no wake boating, you're supposed to stay a certain distance from shore and other boats and sailboats. I think it's 100 feet. I can't remember what's 100 feet or 150 feet, but that's the problem. You could have a wave boat go by a sailboat at 101 feet, and if it complies with statute, still constitute careless boating when it swamps the sailboat. So it's a function of distance. The waves significantly dissipate at 300 feet, not completely. So at 100 feet, they're still pretty high, and it goes down to 300 feet, and beyond that, it dissipates more quickly and quickly and quickly until 500 feet, 600 feet, there's very little impact. So we had a great symposium at Crystal Mountain a year ago that had industry speakers, a U of M biologist, and pros and cons, both sides, and it was extraordinarily good. I mean, there wasn't a lot of finger pointing and so on. And the industry representative, who was outstanding, basically acknowledged the industry has a huge PR problem. And he advocated, he says, look, this is how it should be solved. And we give everyone who buys one of these boats a card and so on. And we try to make this, be courteous, don't initiate it less than 300 feet from shore or any other boat, etc. Don't put your loudspeakers on the towers because that's all over the lake, and don't keep going over the same ground over and over and over. And those are really good suggestions. They're not the law yet. Some states have gone to a 300-foot rule, 500-foot rule, 1,000-foot rule. It looks like the industry probably would not oppose too much a 300-foot rule in Michigan. Maybe they would oppose a 500-foot rule, 1,000-foot rule. They'd probably oppose. So those are the issues. Unfortunately, there are a fair number of lakes in Michigan that have channels and so on that are not 300 feet at all. I'm sitting in a township called Grattan Township, and I'm sure some of my friends from Murray Lake are listening in, about a mile south of the lake I'm on here, and their lake is horseshoe or hairpin shaped, and there are parts of it that might be over 300 feet wide, but not much more. So the problem is, even if a wake boat goes right down the middle, it's going to be 150 feet from shore, and it's going to be hurting, shorelines, and they are. I mean, that's just objective facts. Some people will argue it's the ordinary high water mark, but there are more and more studies that show even when the water's not high, it's a problem. So, one of the analogies I give is, if a new type of semi-truck came on board that had aerodynamics that knocked over every third mailbox, really, how long do you think it would be before they were outlawed or regulated? I think the same thing is true here. I think it's entirely conceivable that you're going to start seeing lawsuits by all the riparians on a given lake against the wake boat operators. It's hard to prove which boat caused which damage, but if they're closer than 300 feet, there could be a class action for a lake, or even a class action, nationwide against the industry. So again, good news is, if they stay 300 feet away, the problem, and don't be blaring loudspeakers on your towers, not such a big issue. If they're on Torch Lake or Houghton Lake or the bigger lakes, and they're 1,000 feet, 2,000 feet offshore, probably not a problem. Bad news is, if they come within 300 feet using the wave operation of the shore, or on smaller lakes, it's not going away, and it's a big problem. I mean, it's just a huge problem. So again, I'll probably have 2 or 3 friends of mine that have these boats that'll be angry at me for this for the next month, but that's kind of where we are. Nothing can be done locally. Townships, cities, and villages probably have no ordinance authority. That's probably preempted. Only the state can regulate it, and probably the best way is a 3 or 5 or 7 or 1,000-foot rule from shore and other boats. On private lakes, if they're deed restricted, the lake association, the strong association, may or may not have the authority to ban or regulate. It depends on their deed restriction. So I'm sure Melissa will have a few questions on this one.
Just a couple, and one was from earlier. If you had any comments on the new legislation giving local government authority to regulate boats during high water periods?
Yeah, I got to be honest. I've been so busy with the coronavirus issues in our municipalities and lake associations. I know one passed. One of the earlier ones was a joke. I mean, it allowed, was it 12 or 14 days a year? That will do squat. And most, you could say, well, 3 days during Memorial Day, 3 days during, most municipalities will say, thanks, no thanks. If there's more substantial legislation that would allow a municipality to do it for, half a season or whatever, that would be of more help. But yeah, right now there is very little that a lake association or municipality can do other than to lobby the state, maybe for a 300-foot rule or 500 or 700-foot rule.
Okay, and then also about the lake size, should there be a minimum lake size or depth for wake boats? And can there be liability for the internal loading or churning up of phosphorus?
Well, in an ideal world, I think the answer is yes, but it's not going to happen for 2 reasons. The boating industry is too powerful, and second of all, the DNR, for whatever reason, has wanted to put as many boats on every lake in the state of Michigan as possible, and that's been their unofficial policy for 50 years. And by the way, the DNR does a lot of really good things, but they don't even size their boat launches for the size of the lake a lot of times. So it's just not going to happen. Liability to a particular wave boat operator is difficult unless, if there's a class action on a given lake against all the wave boat operators, that might be successful. But unless you see and have evidence that a particular wave boat operator is too close to the shore and the wave from that boat drowns someone or slams some boat into a shore station or whatever, individual liability is probably going to be difficult to prove.
Okay, that looks like it for For
Wow.
wake boats, I know.
Local ordinances. I think most riparians do not appreciate how much authority a local government has to help lakes. Many municipalities adopt ordinances that really help and protect lakes. And there's really two types of ordinances. There's zoning ordinances, and then there's everything else, regulatory ordinances. So in zoning, number one, it's always good for riparian owners and lakes to have a really good local city, village, or township zoning ordinance. I can tell you if it's 20 pages long, it's not very good. I'm not saying longer is always better, but it usually is. And you want to deal with the waterfront. You want to deal with funneling, not allowing developments to have a relatively small amount of lake frontage with a large number of units off lake. But ideally, you want large minimum lot size for new lots, 100 feet, 200 feet, whatever. New construction should be set back a minimum of 50 feet from the lake. A lot of townships have 30 feet. 30 feet is nothing. If you're on the lake and someone's sitting their house 30 feet away from the lake, it looks like they're right on top of the lake. And with high water, it's smart to have it back. Private road regulations are good to make sure access to the lakes are safe. Like I said, minimum lot size and width. So there's a whole series of techniques in zoning that your local city, village, or township can do to really protect your lake. So it's also good to try to get members of your lake association on the township board, city council, village council, and on the planning commission so they can help protect your lakes. They can also do what they call non-zoning or regulatory ordinances. These are very common for dock and boat ordinances. How big can your dock be? How many docks can you have? How far does that have to be set back from the side lot line? What's the length? All that good stuff. A few municipalities along Lake Michigan have dune protection statutes that are stronger than the state, and a few have wetlands protection statutes that are stronger than the state. Land divisions are also regulated by local ordinance before you can divide land, but again, the ordinances governing them can be beefed up to protect municipalities. You know, say no, not only can't you create a lot without complying with the zoning, but you can't adjust boundary lines without going through the land division process. So again, many areas that cities, villages, and townships can regulate outside of zoning: size of swim rafts, location, how far out, length of docks. Many municipalities ban permanent docks for the reason we mentioned earlier, size of shore stations, it goes on and on and on.
All right. Well, we have some questions.
Okay.
One is a specific one. Norm is from the south end of Torch Lake. He's in the border between townships and counties, Atrim and Kalkaska. It's not defined anywhere that he can find. Where could you find an answer, I guess, about where?
Your dock?
No, I think it's just because he's between townships and counties. I'm not sure that he knows.
Okay. Well, unfortunately, the jurisdiction of those only extends on the ground to where they are. So if half your lake is in one township and half is in the other, each township's rules and regulations apply only to the portion of the lake and on dry land in their particular township. And the townships will have a map, the county have a map, which will show you exactly where the jurisdiction line is.
Okay, so the county and township maps would tell you which parts are under which control. Okay. How do we get our township to enforce ordinances?
Yeah, that's tough. I mean, I try honey before vinegar, you know, start packing township, you know, meet with the township supervisor, start packing board meetings, give them concrete suggestions. If that doesn't work, run people for those offices. Now, most of the deadlines for filing for this fall are done unless you're nonpartisan, independent, then the deadline is in July. But you know, it all depends. I mean, if you've got a lot of voters on your lakes, these municipalities will normally take notice if you stand up. If all your lake people are non-residents of the municipality, they might not. So try, you know, nice way, this is what we want. If not, start packing the meetings. If they claim they don't have any money, maybe your township, maybe your association might want to donate some money for enforcement.
And this is a great question. Oh, go ahead.
By the way, many county sheriff's departments have summer marine patrols on the lakes within their county. and sometimes they'll supplement them. Sometimes for an additional price, they'll do more patrolling. Now, normally it's got to be three-party. You contract, your lake association contracts with the township, gives the township the money. The township contracts with the sheriff's department, gives the sheriff's department the money. But yeah, you can, in a lot of counties, they will enhance on a yearly basis the sheriff patrols.
And then is there somewhere in Michigan, a township or a city with a good example of well-written ordinances that deal with sidelock setbacks used for docks and hoists? I guess, do you have recommendations for any good examples of ordinances?
Yeah, I do, but they'll skin me alive if I say it here because the townships will be inundated. So why don't you take some names and emails, Melissa, and we can send the people that.
Okay, so if you are interested in information about townships with good examples, you can email info@mlswa.org, and I will get with Cliff and get you some of that information.
Yep. Anything else on local ordinances?
Nope, that's it.
Okay, prescriptive easements and adverse possession. Again, I could spend 2 hours on this and I won't today, but this is what people call squatters' rights. Some people probably find that offensive today, but the phrase is still used. Okay, so this is an old English common law theory going back 1,000 years, and it's true in Michigan and I think all 50 of the states. So the idea is if you use the property, particularly of your neighbor or nearby property, for 15 years or longer continuously, without their permission, you can go to court and claim it. Adverse possession is where you actually use the property yourself for 15 years or more without permission. You claim it and you get title to that property. So the real landowner can't have used it concurrently for 15 years. Prescriptive easement is the same thing, except you haven't used it exclusively. The neighbor you're trying to get it from has, and perhaps others, but you've done it for 15 years or more without permission. You go to court, you get it, okay? There are ethical issues about this, legal issues, and so on. So if you have permission, you can't claim title or an easement. And if the owner of the underlying property can prove you had oral permission, that's all that's needed, okay? If you're a good friend of the neighbor, you probably have implied or implicit permission. So sometimes these lawsuits stem on, and by the way, they're nasty, they tend to be expensive. And by the way, if you get part of your neighbor's land titled by adverse possession or a permanent easement by prescription, you go to court, you don't have to pay money for it. Again, you do not have to pay money for it, but you're gonna pay a lot in attorney fees. So it's gotta be consistent for 15 years or more, so you're gonna get a lot of testimony. I put the dock out that year, no, you didn't, and so on. And you really have to use it a lot. On dry land, simply mowing is not enough. Simply crossing it is not enough. On land, normally you have to, mow it or put up a fence or put in structures or landscaping or, you really have to exercise dominion and control, okay? So that's why it's really hard to get adverse possession in areas that are sandy or, beach sand or whatever. And you've got to do it every year for at least 15 years or more. You can add it onto your predecessor. So if the lot that you own now, you only had for 7 years and your predecessor had it for 10, a lot of times you can add your 7 years to their 10 to get 15. Prescriptive easement is true with joint driveways, walkways to the lake, docks to the lake. So you can get a prescriptive easement for a septic system, a dock, a boat, a walking to the lake, a fence, and so on. But there are also seasonal prescriptive easements. So if you have a seasonal boat that you put in and out or a seasonal dock put in and out every year, but you do it for 15 years or more, you can still get a permanent prescriptive easement. It's just when you get the prescriptive easement, you can't leave the dock or the boat in all year. So these are tough, and I'll tell you why they're tough. They're tough in a lot of ways. They're expensive to go to court. They're witness intense. A lot of times you got the 90-year-old guy or gal who has to remember and testify as to what happened in the 50s. But they ruin friendships and they tend to make people adversarial. The bottom line is if you own a property, And even one of your backlot friends, your neighbors using your property, you either have to say, God, you got to stop. Or you got to say, you got to sign an agreement that you won't claim adverse possession or prescriptive easement. So these are tough issues. If someone else is using your property or build on your property or whatever, you really ought to see your attorney. You ought to deal with it, because being a good guy or gal is going to get you into trouble saying, oh, I didn't do anything for 15 years because I don't like confrontation. I like the person. That could really come back and bite you or your kids someday. So that's a whirlwind tour of prescriptive easement and adverse possession, and I'd love to take any questions.
Yes, we have questions. Can you get adverse possession of a road end owned by a county?
No, in most cases, you cannot get adverse possession or prescriptive easement against a governmental property or easement. So in almost all cases, the answer is no. A private easement, if you abuse it, the courts are not clear. The courts seem to be saying if you already got a right to use that easement, you can't expand it by prescriptive easement. If you have no right to use the easement and use it for 15 years or more, you might gain a right consistent with the other easement holders.
Okay, because there's a similar question about a county road end being used for more than 15 years. So that also would be
If
a
it's
no.
a public road, almost always county, city, or village, very rare circumstances can you get it by adverse possession, extinguish it if you're an adjoining property owner, or get your own private rights if you're a backlot owner or a private member of the public.
If your property includes an easement with the county road commission, do the same laws apply?
Well, your property can be subject to a private easement, or you might own to the center of a public road easement. In most public road ends are easements. You know, you have the right to use it the way other members of the public can. Can you use your half or more? Theoretically, you can, but if you interfere with the public's rights, you can't. So 9 times out of 10, you own to the center, you don't know it, you're probably not paying taxes on it. And even though you own it, you don't have that many, you have a few additional rights, but not that many.
Okay, and then I found some questions in a different spot. I didn't know were here.
Sure.
Can one get a prescriptive easement over state land? So
generally, again, the answer is no. There was a hole in the statute that was plugged 30 years ago on Mackinac Island, where someone adversely possessed or had a prescriptive easement, and there was a flaw in the statute, and they actually got some state land, but that was plugged legislatively. So I would say 95, 98% of the cases, you cannot get prescriptive easement or adverse possession as to a city, township, state, or county property or road end. And again, in almost all cases, the rules for prescriptive easement and adverse possession are the same. The only difference is with adverse possession, you possess it yourself for 15 years and you get title to the chunk of property. For prescriptive easement, you use it in common with others and you just get a permanent easement. You don't get title.
can a riparian claim by adverse possession his dock bottomland?
Yes, but it's exceedingly hard to do because it's not on land, and neither of the parties probably know where the line is. So the answer is yes. Theoretically, someone could expand their bottomlands by adverse possession, more likely by prescriptive easement, into your neighbors, but it would be extraordinarily difficult to prove.
And then we didn't have any more questions about prescriptive easements or adverse possession, but Dave Maturin, our president, wanted to mention on the short-term rental topic that the Michigan Supreme Court is scheduled to have an oral argument on the Spring Lake Township's short-term rental case on May 6th, about 9:30. So that should be televised if anybody's interested in
and just for
taking a look at that.
Not that that's not important, but it will turn on the particular zoning ordinance. So even if the Supreme Court issues a major opinion, it might be only applicable to 10% of the zoning ordinances in the state that have the same language.
Okay.
So interesting, but probably will not be definitive.
Oh, another one came in here. Can a township create an ordinance to prevent the DNR from putting chemicals into their lake?
No, almost certainly that's preempted by state law. Although interestingly enough, there's a Michigan Supreme Court decision from 30 years ago that cities, townships, and villages can regulate and potentially even prevent a new public access site from coming in by the DNR.
Oh,
So that
all
area
right.
is not totally preempted.
Okay,
So can we move on to encroachments and surveys?
we absolutely can.
Surveys are incredibly important. I'm not a surveyor. I have no financial interest. I don't have a relative that is a surveyor. I have some friends who are surveyors. You should never, ever buy property without a survey and without you being able to get out of the purchase agreement if you don't agree with the survey. Don't accept a 5-year-old survey. Things can change. Now you'll say, Cliff, the earth doesn't change. No, but buildings change, sidewalks change, sheds change. So what that survey showed 5 years ago with no encroachments, today there might be a lot of encroachments, or the earlier surveyor might have made a mistake. Same thing, whether both. I think for both a buyer and a seller, it's really wise. On lakefront properties, it's essential because a survey will show the prospective buyers most easements, road ends, how much water frontage it has. You know, is the cottage that you're buying 5 feet over the line into the other person's property, on and on and on and on again. Are encroachments important? Yes, they are. If you're the seller, it might prevent your sale because they don't want to deal with encroachments on another person's property. If you're the buyer and the neighbor's shed or house or driveway is encroaching, it's going to be nothing but headaches for you in the future. So you really want to nail these down. So surveys are incredibly important. Other questions, Melissa?
There was just another one that came in about the prescriptive easements. Could a township employee have a prescriptive easement over private land? Could a township employ a prescriptive easement over private land?
Yes, it could. Let's say your township has a park that encroaches into the neighbor's property, you know, with parking, asphalt, fence, and so on. Yeah, township could after 10 years.
Is there a way to find out if
any landowner can, whether it's a township, a city, private person, corporation, LLC. As long as you can hold title to property, you can potentially have, theoretically, a prescriptive easement or adverse possession claim if the elements are present.
is there a way to find out if a riparian survey has been already done on the lake, but I assume you need it by property?
Yeah. Well, some backlotters can have a riparian survey done if they wonder where the easement goes, but no, these are private surveys. They're rarely recorded. So if obviously if you have it done, you're going to get a copy. Sometimes you show it to the neighbor because you want to convince them, but can I call up a surveyor and say, hey, you did one for Bill Smith? The surveyor will say, I can't release it unless Bill Smith authorizes me in writing. He paid for it.
And then if you have already bought a property with a neighbor's fence on your land, for example, what should you do?
See your attorney. You got to deal with it. You got to find out where it is, how long it's been there. You know, is it too late? If it's not too late, are you going to require them to remove it? Are you going to offer to enter into an agreement? If you enter into a signed agreement allowing it to stay there until you give them a year's notice to take it out, and they agree they won't claim adverse possession prescriptive easements, sometimes it works. But yeah, any encroachment, you better start investigating. You probably ought to see your attorney.
Okay. All right.
So the next topic is special assessments. These appear on your tax bill. They're technically not taxes, although most people will say, who are you trying to kid? Although the courts don't treat them as taxes. Special assessments are for particular geographic areas for improvements that benefit only that area. So a township, city, or village can impose them. So it might be for your lake for weed treatment. It might be a commercial district downtown for sidewalk and facade and landscaping improvements. You know, it might be for a well to pump for your lake and so on. So cities, townships, and villages can do it. Can be used for virtually any project, including even private roads, the upkeep and maintenance of private roads. Also, lake improvement boards can do their own special assessments for aquatic weed control managements and so on. So the process is a pain in the you-know-what. There's a lot of paperwork. There's usually multiple hearings. Normally it's in the newspaper. Normally you get a mailing through the mail that you have a right to contest it or agree and so on. So pros and cons, you know, it's another tax. You can't deduct it on your income tax, even if you're still deducting. You know, the pros are it forces everyone to pay for the improvement, not just some people that get the improvement but don't want to pay for it. You know, the con is it's another tax. And, you know, there's pros and cons as to whether you do a simple special assessment district through the local municipality or statutory lake board. But again, I think if you go into the Riparian magazine, there have been several articles on lake board versus simple SAD, and also on my website, on my articles at Bloomslugget, www.bloomslugget.com. Special assessment districts are becoming increasingly common. They can go anywhere from 1 to 20 years. Any questions, Melissa?
I don't see any questions specifically on that topic.
Next one is,
Then they come in.
Go ahead.
Can you create a SAD to improve a public boat access on a lake you live on?
I think the answer is probably yes. I would have to check the statute, but I think the answer is yes. Yes. Highly
Okay.
like that, and a boat washing station. The
Okay.
question is, how big would the district be? Would it be just the lake? Would it include the lake and some off-lake property owners? The municipality would have to decide. And by the way, a municipality does not have to do a SAD. You can get 100% petitions and they can still say no. Now, if there's overwhelming majority want it, they should do it. It costs them nothing because the municipality, city, township, village can roll all the costs of this district, including the attorney fees and publication costs, into the district, so they don't pay a dime. But you can't force them to do one if they don't want to do it.
Okay, and then as an association, if we have a special assessment, should all members of the association pay the same amount?
Well, you're contradicting yourself. They're two different things. A special assessment goes through a government and is on your tax bill. So it's either a statutory lake board, which is government, or it's a city, village, or township. Most associations are voluntary dues, and if they have an aquatic weed treatment program, it's through dues, and you can't force other people to donate for weed treatments unless it's a strong association. So what I'm talking about, assessments are not association dues that some people call assessments. They're formal government special assessment districts through either an independent statutory lake board or city, township, village, or county.
And then would you happen to know the average assessments per property for aquatic invasive species treatment in Michigan?
You know, it's all over the board. I think you'll see they probably run between $75 a taxable parcel to $300. Most of them are probably in the $100, $150 range. Now, I've had this argument with a lot of people in the past. I got it. If you're opposed to chemicals, that's one thing. If you don't think it'll do any good, but people that argue on cost, really, you got a $400,000 property and you're going to argue over $100 a year. And they tend to be pretty cost effective. And the other thing you should remember about special assessments for aquatic weed treatment, not only does it a lot of times enhance the value of the property, but sometimes it's a safety issue. Sometimes some of these lakes, it's simply unsafe for swimmers and kids and dogs and so on to get caught in some of these weeds. It's really a safety issue, and not all, but some lakes.
And then I was going to say too that MLSA does have some of that data. So I sent my email address to you, Carol, so that you can email me and I can give you some rough data that we've collected on what people are spending on SAD assessments and how many are actually using SAD assessments. Can SADs—
By the way, there are probably in the state of Michigan, see, you don't have to register them with the state. There are at least 100 lakes in the state that have special assessments at any one time, and it might be as high as 200-300.
Okay. So let's see. Can SADs cross county lines?
Only if you have a statutory lake board that crosses county lines. Otherwise, you have to do separate ones in each municipality. So if a lake straddles 2 townships and 2 counties, you have to set up a separate one in each of the 2 townships.
And then a follow-up about your comment about association fees versus special assessment. Are all association fees voluntary and not enforceable?
Okay, we get back to the strong versus weak lake association. With the weak association, the dues are donations. They're not enforceable. With a strong lake association, particularly if they're deed restrictions, most of the time, yeah, it's mandatory, and they can put a lien on your property if you don't pay them.
All right. I think we can move on.
Let's move on to state statutes. We've already talked about city, village, and township ordinances. There's state statutes that affect the waterfront. Almost all of them have been codified into the environmental code. So there's what used to be called the Inland Lakes and Streams Act. That's a portion of the environmental code, which is found at MCL 324 in various sections. That basically says you can't do anything waterward of the ordinary high water mark without a state permit. You can't put in a seawall, you can't put in a permanent dock or pier, you can't have a marina, you can't dredge, all that stuff, you got to get a state permit. So if it's at the ordinary high water mark or lakeward or streamward of that, got to go through the state and get that permit. Dune Protection Act is mainly on Lake Michigan. You can't do hardly anything in a protected dune area without a permit, but it's Lake Michigan, not only on the lower peninsula, but parts of the southern upper peninsula. Wetlands Protection Act, local municipalities can regulate certain smaller wetlands that the state can't, but again, the State Wetlands Protection Act is pretty extensive. And then finally, the Natural Rivers Act allows certain rivers, streams, and creeks to qualify for enhanced regulations and protections. And again, there are probably several dozen major rivers in the state that have the Natural River Act with their own types of zoning or zoning that's on top of local zoning. And then many streams and creeks are tributaries within that system. Probably no questions on that, Melissa.
Nope, not right now.
Next is something I just want people to think about, maybe read about the public trust doctrine. This is kind of a amorphous, will-o'-the-wisp phrase that the courts really haven't wrapped their arms around. They've used it in some areas with precision and not others. So generally, if you've got a navigable waterway, it's impressed with a public trust. It has to be used for the benefit of the public, navigability, and so on. If it's a private lake, it's probably not subject to the public trust doctrine. And then most water withdrawal is not subject to the public trust doctrine, but it is subject to reasonableness. So you'll see the courts and DNR officials and EGLE officials and attorneys use this public trust doctrine argument, but it's a pretty, means different things under different circumstances, and it's kind of a complicated concept. So I just kind of want to throw that out there. So let's move all the way to page 24. Lakefront liability. Now, I believe, Melissa, we're going to be having another webinar that Mark's going to do in a week or two.
He is going to do that a week from Friday, which is, I believe, May 8th, and that'll be at 1 o'clock.
That'll be a really good seminar. So I'm just going to touch on this in general. So we are a litigious society. I do very little plaintiff's personal injury work, just as a caveat. And, you know, you can get sued for anything. The question is, will you be liable? And that's why you want good insurance, not only if you're liable, but just to get out of a lawsuit when you have no liability and they shouldn't have sued you, can take $10,000 or $20,000 in attorney fees. So when you go to the lakefront, the liability potential is increased geometrically, exponentially. And we all know why. The lake. People can drown, they can fall off docks, boats can run into people, you know, et cetera, et cetera, et cetera. So you try to minimize liability as much as you can. Don't leave obviously unsafe things around, don't have too many sharp edges and so on, but you can't possibly protect against or foresee every problem. So the answer is good insurance. Now, again, I'm not an insurance agent. No one in my family is, but for peace of mind, if you own a waterfront property or you're the beneficiary of an easement or whatever, or you're on a private road, get good insurance. You should have a minimum amount of $1 million, and that's generally not enough. Usually you should get a $1 or $2 or $3 million umbrella on top of that. The umbrellas aren't that much unless you have teenage drivers like I do. But it's really important. Get good insurance. And remember, your cottage, your dock, your private road might be under one policy, but your boats and ATVs and side-by-sides will be under a different policy. They might all have the benefit of the umbrella, but check with your agent. So get really good insurance. The other thing that you should really think about is Michigan had its insurance so-called reform statute went through about a year ago. It really kicks in for autos probably in another month or two. And there's a sliding scale, and premiums will go down depending on it. You can still have the full coverage, full medical coverage, and then you can get lower ones, I think 250,000 and 100. I would strongly urge you to stay with the full coverage. I think you're still going to get a break compared to your old coverage. I'm not really sure how that applies to boats, whether it's the same, unlimited, or whatever, but if you have a severe accident and you become a quadriplegic or a paraplegic or one of your family members, the other limits are not going to be much. And then you're going to be under, Medicare, Medicaid, other stuff. It just really, if you can afford it, you should stay with the full coverage, medical coverage. So again, think about your insurance. If you have waterfront property, review it with your agent every couple of years, whether they come out or you give them a list. If you have more than one lakefront property, cover them both. If you have a vacant lakefront property, make sure it's covered because people can still get hurt, particularly if you have a dock there or a boat. So you can't envision and prevent against every liability potential. Therefore, you need good insurance. And even if you could against every potential liability, you're still going to get sued in a lot of cases, and it's going to cost you a lot of money to get out of the lawsuit. So anyways, if you're a lake association, you should have liability insurance, particularly if the lake association has like an ice cream social or a boat regatta or a boat ramp. Even if you don't, I would still have liability insurance just in case. The director's professional, directors and officers err in omission liability, depending on the cost, you should get it. Very rarely are lake associations sued for malpractice or whatever, but it's nice to have the insurance. So, Melissa, that's kind of a preview of what Mark will probably be discussing.
Mm-hmm. Someone did have a question about that. If someone is hurt or killed while partying on your bottom land, what is your liability?
In Michigan, normally you only have liability for something you can control. Unless you have an artificial, I mean, if you have a fence post out in the water, and even if someone's trespassing, you could have liability. And again, the problem is getting out of a lawsuit. If someone is injured or killed, everyone on the block is going to be sued. The dog down the street is going to be sued. Everyone, I'm being facetious. And it's going to cost you money to get out of the lawsuit. So insurance will cover not only a potential award against you if you're found liable in court or a settlement up to the amount of the policy, but will pay your attorney fees to get out of it if you're totally innocent or without liability.
Okay, well, we can move on.
Let me talk about a topic everyone is tired about, the coronavirus, because our firm represents a lot of municipalities. So let me just give you a municipality perspective here. Under the governor's original and continuing order, municipalities' offices are generally closed to the public, and there's even a limited number of essential employees for the office that can go in. We have no idea when that's going to be lifted. My prediction is municipal offices will probably be open gradually. Probably the governor will eventually say, okay, it can open for all the employees, but not to the public, or 50% of the employees can go back, and do a safe distance and wear masks and so on. So it'll probably be open gradually. These municipalities have tried to do their best to conduct business while they're shut down, but some things they simply can't do. Most of them have not been able to issue zoning permits, building permits, land divisions, because they got to get out and inspect these sites, or a building inspector is a non-essential and hasn't been able to work remotely or whatever. So when these municipalities open, there's going to be a real backlog of stuff. So if you're thinking about, trying to get them to enforce something or an application or permit, it could be weeks or months. Even if a contractor tells you, hey, you're first on the list, and as soon as they lift this, I'm going to be out there, the contractor has to finish the house he or she didn't finish in March. The supplies might not be there when we're reopened up for weeks or months, and the subcontractors might not be there for weeks or months. So just be forewarned that with the municipalities, most of them are really doing their best, and when they're open, they'll do their best, but there could be significant delays. Also, one thing that I think a lot of people haven't thought about is contracts. I mean, in a given day in Michigan, we might have, 20 million contracts in effect, from leases to your cell phone to everything. And nationwide, probably billions of those. Now, some of those contracts have what lawyers call a force majeure clause, FORCE space MAJURE clause. That basically says if there's an unforeseen calamity, act of God, right, or whatever, one or both parties can cancel this contract. So it's going to be really interesting what happens with all these contracts. Some will simply be renegotiated. Both parties will say, look, I don't want to just walk away, let's renegotiate. For the contracts that don't have that clause, the interesting question is whether the courts will read it into those contracts. So, you know, there are all kinds of issues. You know, you sign to have a house built for $300,000 and you can't afford it. Are you going to have to go through with it? Depends on your contract. Or can you renegotiate it down to, or can the home builder cancel? You signed for $300,000, you got a great deal. And that's still a great deal. Can the home builder walk away? So obviously the economic impacts of this and the shutdown are going to be unbelievable. But just contracts, that's just a good example of where, you know, contracts that lake owners have with people to put in docks and boats, to paint their house, to weed treatment, on and on and on. It's just a big question mark at this point in time. I know from the waterfront, a number of services and laborers and employees have been deemed essential. If there's a dam on your lake, that's essential. Water system, private, that's essential. I think the governor, I'm not positive, but I think, and maybe Melissa can answer this, has deemed weed treatment to be essential. Drainage problems are essential, you know, and so on. So luckily, many of those. Now, I don't know that dock installers, marinas, marina prep, I don't think that's been deemed essential yet, but I don't know for sure. So I don't know, Melissa, do you know about the weed treatments? Have those been deemed essential?
I think I think that might still be up for debate. We did submit a letter on behalf of MLSA and our members who are businesses that do weed treatment, and obviously our lake associations who would like weed treatment to continue. We did write a letter hoping for clarification on that. And I just got a comment from someone saying that they believe that because landscaping is okay, that perhaps it's okay to proceed. I think part of the issue with the lake treatment was the concern about not being able to use motorized boats, and that has been lifted. So I think that with the most recent easement of that executive order, you know, the restrictions in the executive order, I think that we are okay to go. But, you know, that's pending another executive order. So.
Sure. Again, our website, we've had coronavirus updates every 2 or 3 days. So we've got a lot of information on there about coronavirus, municipalities, lakes, and so on. Not to mention, you know, various lake issues, www.bloomslogan.com. The Michigan Township Association has a good website that I've mentioned. MLSA has a great website that you should visit regularly. Melissa, we've gone longer than we thought, but the nice thing about a meeting like that is they can leave the room and not feel like they're insulting us.
Yes, that's true.
General questions about the lakefront or municipalities, I'd be glad to take a few more minutes.
There were a couple of things, and then I just wanted to tell everyone that the Glen Lake Association also had authorization to open their boat wash station because they were told that invasive species protection is essential to environmental protection. So just a little bit more clarification on that. I had a question from the same person who was asking about the association dues. So they're wondering if their association is a strong association if it has deed restrictions.
It probably is, but you'd have to look at the restrictions and how comprehensive they are. But a strong lake association, the deed restrictions would create the lake association, you know, let's say the ABC Lake Association, say that all lot owners have to be members, that the association has dues powers, that they can enforce it. And then beyond that, they might have a lot of different powers. They might have, you know, they might control the boat ramp. They might own the bottomlands. They might have architectural control review. It all depends on the particular deed restrictions involved and whether they're strong and whether they cover the whole lake.
Okay. Let's see. Okay. I know we had one. from earlier. All right, if you have a survey that shows a little point out into the water that still shows an access, that still shows access to your property, but now it's underwater and your neighbor has their whole boat lift on it, did the bottomlands change?
No, and I don't want to get into your particular situation, but
Okay.
no, just because of high water or low water, the riparian boundary lines stay the same.
Okay.
Not
How do
the
you
lakes.
apply for an inland seawall or riprap permit to combat erosion?
Okay,
What
I
types
would
of erosion
recommend that
control?
you not do that. You should hire a really good contractor who will do that. Don't do it yourself, unless you're doing the work yourself. But normally, a really good contractor knows that like the back of hers or his hand, and it's going to be more likely to do it right, to get it quicker. Unless you have a contractor who's made the Eagle angry or something. But the way you do that is get references. So I wouldn't even do it yourself. If you're on an inland lake, it's going to be Eagle. If you're on the Great Lakes, it's going to be both the Federal Army Corps of Engineers and the Department of Eagle. But again, I think they have a unified permit application. So if you apply to one, it goes through both. But again, your contractor should be doing all that, your professional contractor.
Mm-hmm. And you probably make sure your contractor is getting permits as well.
Licensed and insured.
Mm-hmm. All right. I have no more open questions.
Well,
If there's
Melissa, go ahead. I'm sorry.
no, I was just going to say, kind of last call. But go ahead, Cliff.
Yeah, I would like to thank everyone for watching this webinar. As Melissa said, in case you want to watch it again, and I don't know why anyone would want to go through this twice, but if you do, or if you have friends or family members, it'll be on the MLSA website. We would like to thank the Glen Lake Association for co-sponsoring this with MLSA. And again, you've got two really good webinars coming up, maybe more, one on liability and the one on short-term rentals. So again, thanks everyone for tuning in, and MLSA and I very much appreciate it. And we hope to see you next year at Crystal Mountain.
Yeah, in person would be nice, right? Yeah, so we are so pleased that Cliff was able to join us today. I know that this information is, very popular. People really, there's a lot of ins and outs, and Cliff is definitely an expert. So we appreciate his time today. And I did want to echo what he said about this series. Thank you to the Glen Lake Association for sponsoring it. We have 3 more sessions on the next, well, not the next, the 3 Fridays in May. May 8th is about insurance issues and liability. That's at 1 p.m. on Friday, May 8th. On May 15th at 1 p.m., we have a session about harmful algal blooms. So that should be a good session to attend. That's also at 1 p.m. And then our final session about short-term rentals will be on May 22nd, and that is actually at 2 p.m. on that Friday. So we absolutely encourage you to join us for our upcoming sessions. Like Cliff said, check out our websites. Become a member, support us, subscribe to the Riparian magazine. We appreciate your support. And if any other questions come up, you can feel free to email info@mlswa.org, and we can try to help you out. Okay? Everyone have a really great rest of your week. Bye. Thanks, Cliff.
Thank you.
Bye.